And welcome back to On the Nose. So we are going to kick off today's webinar on Bill 148, Changes to the Employment Standards. I seem to have seen something about this in the press over the last couple of days, Sean. I don't know about you, but a couple of mentions. So some questions beyond, and that's some of the things we'll be. My name is Keith Gallup. Easy. Well, the first two parts are easy. I'm going to introduce Sean and field questions at the end. In between, I'll be hoping the technology continues to work during the course of the next 45 minutes. Questions, please do send them in. There should be a dialog box on your screen that'll let you send them in, and we'll save some time at the end to address some of those. As well, the handout from today's presentation should be on your dialog box as well, so you can download the notes from today's presentation. If by chance you have any difficulty with those, by all means, just drop me an email and I will follow and send you a copy of those slides. Is Sean Bawden. He is a partner in the employment group at Kelly Santini. He advises businesses and individuals on all aspects of employment law, including discrimination claims, wrongful dismissal, WSIB claims, pay equity, and human rights. Many of you may know Sean from his blog, the award-winning blog Labor Pains, which just 10 short days ago was named blog in Canada by the Clobbies, otherwise known as the Canadian Law Blog Awards. Today's topics, I mentioned there's lots of different things beyond minimum wage in this new legislation, so here is the list of the many different topics that Sean is going to be going through over the next half an hour, 40 minutes or so. And without further ado, I will pass things over to Sean, take you through. I asked Sean about half an hour ago if he wanted to have the video on, and he said he put a tie on, which I didn't do. So we are going to have to keep the video on. You'll see my name on the screen, but we're together, so we just have logged in once. So we're going to just play a little musical chairs, and Sean will come and start the presentation.
All right, so good afternoon, everyone. I did put a tie on. It smacks of effort, which I don't appreciate at all, but here we are. So I thank you for joining us this afternoon. Keith is correct. Bill 148, the headline-grabbing change has not gone unnoticed. Apparently, there's a donut shop in this country that has done things, and the media seems to have noticed. So I'm going to touch on minimum wage, ways that employers can make changes to the terms of employment as a result of that, and touch on some other things. So quickly, I'm going to look at Bill and changes to the Employment Standards Act. Bill 148 also changed the Labor Relations Act, not going to touch it, and also the National Health and Safety Act, and one, which is that shoes are can no longer be required. So, if you're running a restaurant or something like that, you may want to look at those changes and the obligation that you impose to wear high heels. So let's start with minimum wage. So the headline is now minimum wage is $14. That is true in large part, but there are many, many exceptions, as you see on the slides here. So if you have someone that is earning tips and serving alcohol, the amount is lower. If you have someone who is both a student and under 18 and they work fewer than 28 hours or it's a school holiday, they can earn less. If someone is a home worker, they earn more. And my personal favorite, which I assume applies to all of you, if they are a hunting or fishing guide, there is a prescribed daily amount. It's not on the screen because I kid, but if that is your industry, look it up. Important to note, there are many, many exceptions to who qualifies for minimum wage. Those exceptions are by regulation. That number appears to be expanding as the government tries to catch up and respond to issues that employers are raising with respect to minimum wage and hurt that certain industries are feeling. So for a long time, the exceptions to minimum wage and certain other elements of the act included essentially professionals governed by college. So lawyers such as myself, doctors, it was all set out, firefighters, teachers, those all continue. And so if you were exempted from minimum wage before, you still are. And some new people are being added to that as a result of these changes. And so, before you rely on the headline grabbing, it's now $14, just bear in mind that there may be exceptions that apply, or you may actually have to pay more. Other thing to note, all these numbers change you see on your screen go up in less than a year on January 1, 2019. So the $15 is going to come into effect as kind of the general wage. And then less headline grabbing, October 1st, 2019, it will probably go up again. And so as of October 1 of next year, we go back to the old model for minimum wage increases, which is, so presuming that inflation goes up between Jan 1 and Oct 1 of next year, you can expect minimum wage to actually go up again effective October 1st of 2019. So likely next year, the general minimum wage is likely to be 15 and change for what it's worth. So just FYI on that, and I'm sure you're all ecstatic about it. Overtime pay. I'm not gonna spend a lot of time on this because it probably doesn't apply to most of you. In short, if for some reason you pay someone two different rates of pay, i.e., let's be completely ridiculous. On Monday, they make $15 an hour, but on Tuesdays, they make $16 an hour. You now need to keep track of how many hours they work at each wage rate. And if overtime is earned, they earn overtime the wage rate at which they were accruing those overtime hours. Painfully complex. But in short, you got to figure out how many hours they worked on Monday and how many hours they worked on Tuesday, i.e. how many 15, how many 16. And if over it has to be at the, you have to pay them at the rate that essentially they work the hours. If you drop me a note, I assume this doesn't apply to all, so I won't spend my time on it. Vacation pay. Vacation pay is much more relevant, I'm going to presume, to many of you. And so what the changes provide is that if you have an employee who's been employed for 5 or more years, they are now entitled to essentially 3 weeks of paid vacation. So it's 3 weeks of time plus 6% of wages after 5 years of employment. I wrote, you'll see the link here in the slides. If you're looking at them, that should be an active link. I've argued that the way the is written, that's 5 years of continuous employment. And so not 5 years added up together. So if you have seasonal employees who have worked for many seasons, I don't believe that just because this is their 6th season, that necessarily does one have to provide the 3 weeks of paid vacation. Of course, if they don't work full years, that's a eligibility criterion that would have to be looked at. But that's essentially where I start. People who go off on certain forms of statutory leaves of absence, and we'll look at that in a minute because those have changed, that is going to be counted. So if they're off on mat leave, for example, you can't say, well, they haven't worked here for 5 years continuously, they went off on mat leave. No, that's going to be included in the time. So important to note that. The other thing to really notice, and I've noticed this in terminations, is that you have to be mindful that when you're terminating an employee's employment, there is a obligation to pay vacation pay on the statutory amount of termination pay. So if someone's been employed for, let's say, 2 years, the ESA prescribe, well, that's, sorry, bad example. Someone's been employed for 6 years, the ESA provides that you must provide them at least 6 weeks or pay in lieu. If you're going to go the pay in lieu route and just give them a lump sum of cash at the door on termination, bear in mind that the vacation pay amount that has to be paid on that 6 weeks is now 6%, not 4%. So if you have old templates and old Excel spreadsheets, just bear in mind that you have to be mindful that employees with longer service are now entitled to a larger amount of statutory vacation pay on their statutory termination pay. Simple? Sure. Holiday pay, stat holiday pay. So this is going to really affect those who have a whole lot of part-time employees, and it is going to drive up the cost of doing business for those who employ a lot of part-time employees. This is not what's grabbing headlines. You're not going to see this in the media really getting reported. But in short, what the government has done by virtue of these changes to the ESA is that if you employ part-time people and they worked within the 20 days preceding the statutory holiday, then what you need to do is calculate how much money they made on the days that they worked, and then divide by the number of days worked. And that's how much you're gonna have to pay for public holiday pay on a stat holiday when you're closed. The change is that you used to take how much money they earned in that preceding period and divide simply by 20. And so if you had someone who worked 1 day a week, for example, in a 20-day period, you'd probably be dividing by like 3. Now you're going to divide by, divide by 20, small number. Now you divide by 3. That's a real difference. That's really going to increase. And so if you have a whole lot of part-time workers who work, throughout that period, you're going to see the amount of money required for stat holiday pay go way up, because you're going to have a whole lot of people getting captured, and as if they all worked on that day. And so theoretically, on a stat day, you're going to have potentially 200 employees notionally working, all as if they worked their regular shift. And so that's just something to be mindful of. There's not a great deal one can do other than to be mindful of when people are being scheduled coming up to holidays. And sometimes business operations will simply require that you have part-time people working in advance. I've seen employers getting creative in this respect and really turning their mind to when those holidays fall and then what they're going to do with staffing. If you want to look at that, I can certainly assist you, but it is something to be mindful of. And that Christmas New Year's corridor, as I call it, where you get 3 stats on Christmas Day, Boxing Day, and New Year's Day, that's really something to look at when you're doing your Christmas scheduling, which if you're in retail, good luck not having more employees. Somewhat out of order here and changing gears. So mischaracterization of independent contractors. So as of the date that this law was signed into law, which was November 27th, 2017, there's a new statutory prohibition from treating workers other than as employees. And so a lot of businesses will try and reduce payroll obligations, reduce tax obligations by describing workers as independent contractors. And in a lot of cases, they aren't. Everyone kind of winks and nods at one another, but they're not. So where we see the challenge arise is when the relationship breaks down and the worker applies for EI. Well, lo and behold, Service Canada advises them, you're self-employed, you're not eligible for EI. What are you doing here? And the worker takes the position, well, really, I was an employee. That's what happened. So I'd like my EI, please. They can apply for a determination from CRA and Service Canada as to what they actually were. In a similar respect, the Ontario Ministry of Labour is more than happy to look at the situation to make a determination as to whether or not the person is quote unquote an employee and therefore covered by the protections of the ESA, entitled to stat holiday pay, as I just went through, or vacation pay, etc. And so the presumption now, the statutory presumption, is that workers are employees. And the onus is now on employers to demonstrate that if the worker is not an employee, that the employer is right. I don't think that's a massive shift. I really, really don't. In my experience, that's kind of always been the approach that I've seen CRA and the Ministry of Labour take. Paper is great. A good contract will certainly assist, but the reality of the situation is that what CRA says is that they will look at your contract and then they'll look at what the circumstance actually involves. And so just be mindful of that. People have asked me as to whether or not there's going to be a fine imposed for mischaracterization. I have not yet seen it myself. I've gone looking for it. I've gone looking for it in the regulations. I haven't yet seen it myself. I've seen others who do what I do comment that it could be substantial, but I haven't actually been able to confirm that yet, that there will be a fine imposed for the mischaracterization, in addition to the employer having to pay whatever may be required to the worker as an employee. I mean, obviously that flows. If the person was mischaracterized, and they're going to be entitled to whatever they would have accrued, whether it be a fine on top of that, I suspect the answer is going to be yes, but I haven't yet seen that in the regulations, and I looked last night and I didn't see it yet. Speaking of getting things wrong, unpaid interns. Less of a hot button issue now than it was a couple of years ago, I guess. And so in short, the definition of employee is now changed. And so it now is defined to include anyone who is receiving training from an employer. So basically, unless this person is tied to a post-secondary co-op program, they're an employee. That's essentially the way it's going to shake out. And so what that means is that the individual is going to be entitled to minimum wage as applicable, and maybe they're a student and under 18, the lower wage, but you still got to pay them. And they're going to be entitled to other things like vacation pay, stat holiday pay, various forms of paid leave, which we'll talk about in a minute. And so, those who use quote unquote interns, I'm going to say that, and I've said this for a long time, those days are probably up. And so unless the person comes to you with an approved post-secondary program signed off by an institution that you've heard of, pay them. I don't see any real way around this. That's kind of the takeaway there. Yeah. All right. Equal pay for equal work. And so pay equity and the Pay Equity Act, which is quite old legislation, has provided that essentially jobs predominantly done by men and jobs predominantly done by women have to be paid at the same wage rate. I'm not going to go into pay equity. It's confusing. This is much more fun. And so what this provides is that if you have a part-time worker doing substantially the same work as a full-time worker, then those two employees need to be paid at the same rate, subject to the exemption I'll talk about in a second. So there was an article in the Ottawa Citizen yesterday about this. Essentially, it provided that if you have a university student who comes in at Christmas and gets the title of assistant store manager or something, but they only work part-time hours and really they've only been there for a little while, and you have a 20-year seasoned employee who works every day, they work through the doldrums of January and February, they are to be paid essentially the same amount, because what the government has essentially said is they don't want to penalize those who can't work full-time. And so in this fairer workplaces objective, the intent is that if you have people doing substantially the same work, working side by side, then they should be paid essentially the same wage rate, regardless of whether one works full time and may understand how the business works better than the person standing beside. That's how it shakes out. That doesn't come into effect for a couple months, but it's coming, and it's going to raise some issues and probably some tensions among more tenured employees. And so what the law permits is distinctions based on seniority systems, merit systems, some other objective factor that you can point to. And so if you have a long tenured employee who works full-time, that's probably going to be all right to pay them differently from someone who just started. You know, there's a reflection of the institutional knowledge there that can be reflected in pay rate. But, you know, if the only distinction is that someone works full-time and someone works part-time, that's not going to be on. And so if you're going to pay someone differently, you're going to want to have established, written realistically, criteria by which you are evaluating the distinctions, the objective factors. So maybe employees over 5 years are paid $1 more per hour, and those, you know, over 10 years are paid more. That's going to be fine. I mean, you can point to that and say, well, you know, she's been here longer, she knows more. I pay her better. And if the new employee stays, well, he or she will be paid accordingly. So just something to bear in mind. But if the only distinction between them is one's full-time and one's part-time, that's not going to be on. Also bear in mind, of course, the Human Rights Code, which I don't want to get into, but if you're drawing distinctions on the basis of any prohibited factor, so age, sex, marital status, stuff like that, that's going to be a violation of the Human Rights Code in addition. I'm not going to get into that, but if you're drawing distinctions based on those sort of elements, you're going to have more problems. The other interesting thing to bear in mind is a lot of employers get a little squeamish when employees start talking about how much money they make. That always, to my mind, has been a little problematic because the Labor Relations Act and union organizing allows people to talk about conditions of employment for the purpose of considering labor organization. ESA reprisal provisions are now going to provide that employees can essentially talk to one another about how much money they make in order to ensure that their employer is properly paying them. So the part-time person can go to the full-time person and say, hey, I'm making minimum wage. How much do you make, you know, all the time? Now, there's no obligation for the full-time person to answer that question. They can absolutely tell the part-time employee to mind their own business, but you can't get involved as the employer. The employer cannot, by contract, say, don't discuss how much money you make, and, you know, please don't tell the part-time employees that you're actually making $2 more an hour because you're full-time. That's illegal, and in order to ensure that that happens, in order to ensure that pay equity is achieved, they are permitted to talk to one another. And if you penalize them, that's going to be an act of reprisal, and the ministry can step in if a complaint is made. So FYI on that. Good. Let's talk about leaves of absence, because this is getting consideration. So a lot of changes to leave of absence, a lot of changes on the pregnancy and maternity front. So in short, there's a lot of numbers on this page, but in short, pregnancy leave is now, pregnancy/parental leave is now 78 weeks. That goes hand in glove with the EI changes that the federal government announced. There are changes as to when that can start, how it can be split between parents, how long it can last. These are particular, and, you know, there's a lot of numbers here I don't want to throw at you in this sort of base, but in short, bear in mind that pregnancy parental is up. Also, now up is family medical leave, and these are now entitled to take leave to take care of any critically ill family member. So it expands the people that it applies to. And just on this, I want to point out that these forms of leave are unpaid leave. We'll talk about personal emergency leave in a second, but a lot of forms of statutory leave of absence in the ESA are unpaid. There's no obligation to those statutory employees. You can, by contract or by convention, demonstrate that you will pay them while they're off. You know, pregnancy top-up, etc. It's not uncommon whereby employee goes off, they draw ESA for parental leave. That's a small sum of money. And in order to try and retain that person and perhaps attract them initially, the employer them up. That's contractual. Outside of any sort of perk or benefit that you're offering, there's no obligation to pay these people while they take these forms of leave. In short, you can't fire them for taking these leave. That's really what this comes down to, is it's job protection. So that's to be borne in mind. You know, the child disappearance and child death leave, I joke about, not because it's a funny topic, but because I honestly have to query what need there was to have passed this. I just cannot imagine that a lot of employers were firing their employees because of this, and this was such an epidemic that the government had to step in. But stranger things would surprise me. So now, if your employee suffers the loss of a child, they can take up to 2 years to deal with that, and you can't fire them as a result of taking time off. Good. I just can't. I can't imagine anything worse in someone's life. And so the notion that people were getting fired because their child died, again, I don't know what problem this was really solving. Similar, if a child disappears for a crime-related reason, employees can now take up to 2 years to deal with that. Okay, there we go. So again, unpaid leave, don't fire them because their child disappeared, or it used to be that they were murdered. Now it's that they die. Again, this seems easy to me. More interesting is the domestic or sexual violence leave. And so this is not only for employees, but for children of employees. And so employees can now take up to 10 days and up to 15 weeks off if they are or their child is a victim of domestic or sexual violence. And so employers are also obligated to pay such employees for the first 5 days of leave. And so if you have an employee who is the subject of domestic or sexual violence, or their child is the subject of domestic or sexual violence, you now you have to provide job protection to these employees for quite a substantial period of time. And in fact, the first 5 days have to be paid. And so this applies, you know, if they're fleeing and they have to move, they have to find somewhere to live, that'll apply. It will also apply if a parent wants to attend the trial of the person against whom their child has made accusations. And so if there's a criminal trial going on and mom or dad wants to go and attend that trial to be supportive of their child, the employer not only has to provide the time off, but they may have to pay the employee while they're gone, pursuant to the ESA. And so this is a pretty drastic change to the law. I suspect that it's not going to apply that frequently, at least one hopes. But what the Premier said is essentially this should enable employees who are considering leaving domestic violence situations, but are concerned about their job or concerned about money to do so. And so there's some real social engineering going on here. Again, I don't know the extent to which this is going to apply. I don't know the extent to which employers are going to see this. It's not making a lot of noise, such that I don't think a lot of employees are going to be aware of this. But you know, employers, as part of your OSHA duties, you need to be mindful of the risk of domestic violence, and you know, as part of your responsibility to employees. And so if you suspect that one of your employees or even one of your employees' children may be in a situation from which it would be prudent to remove themselves, you may want to have that awkward conversation and say, you know, look, I'm aware of what's going on in your life. You know, I'm required to by law to do so. You know, there is this form of leave. You know, not only am I required to give it to you, but I'm letting you know this because I think it's a good idea. You may want to have that conversation. You may want to point out that there's a form of paid leave if they choose to exercise it. It's a conversation that you may want to have with your employees, bearing in mind not only these new allowances, but also what's required under OSHA. So I raised that. Personal emergency leave, i.e. paid sick time. And so the changes to the ESA in respect to personal emergency leave essentially provide that all employers, regardless of size, and I know some of you sent me questions in advance when you registered to say, are there any allowances for small businesses? In this respect, no. In fact, it went the other way. It used to be that personal emergency leave only applied to large employers, so those who employ 50 or more. They removed that. It's everybody. And so now all employees who have been employed for the whopping sum of 1 week are entitled to personal emergency leave, the first 2 days of which must be paid. And so the law makes pains to make this patent that not only are employees entitled to 10 days of personal emergency leave for pretty much any urgent situation, and I'll talk about that in a second, that affects them or even a family member, but the first 2 of those must be paid. And so, if they advise you that they're taking personal emergency leave, then you have to pay them for the first 2, and essentially the amount to be paid is what they would have earned on that day had they not essentially called in and say, I can't work. And so this can be used as paid sick leave. This can be used as bereavement leave because it applies to the death, not of the employee. You have to pay the employee 2 days personal emergency leave if they pass away. But if they have a death in the family, then yeah, that can qualify as personal emergency leave. And so if you're an employer and you have existing sick leave policies, as a lot of you do, or existing bereavement leave policies whereby you provide paid leave for that, you may want to look at how much you're providing and whether there's now overlap. And I had an employer ask me the other day, said, I provide bereavement leave. Do I have to provide that in addition to this personal emergency leave? And my answer was that it's a function of contract. So if you're allowing 2 days or 3 days of bereavement leave as a portion of contract, and you don't say that that's subject to the personal emergency leave provisions, then the 2 are going to be concurrent. They're going to be entitled to both. So you may want to look at your employment agreements if you have them. If you don't, you should have them. Buy them from me. It'll save you a ton of money. Or if you have an employee handbook or something along those lines, you're going to want to look at your leave provisions, your paid leave provisions, because the changes here are substantial. So 2 days of paid personal emergency leave. And in that, and this is really driving a lot of my employer clients around the bend, employers can no longer ask for essentially a doctor's note to justify taking personal emergency leave. And so now saying the fact that it's paid. So if an employee says, I had to take 2 days of personal emergency leave because I was sick, and it's the first 2 days they've taken that year, you as the employer, regardless of size, are going to have to pay them for those 2 days. You are not entitled to say, where's your doctor's note to prove you were sick, but the law does provide that you are entitled to evidence reasonable in the circumstances that they were. So what is evidence reasonable in the circumstances? I don't know. Sorry. This is new. The Ontario Labour Relations Board hasn't looked at this yet. The government hasn't given us a whole lot of guidance on this. There is some old case law from the Labour Relations Board that looked at similar provisions in other statutes and said what counts. And what the board said in that case was, a statement can count. And so if the employee tells you that he or she was sick, well, why would you ever disbelieve them? Which I appreciate is challenging. What I've been recommending to employers is if employees want to apply for this personal emergency leave, they got to sign a form. They got to sign essentially a declaration that confirms that, yes, in fact, they took it legitimately. And the reason for that is that people get really weirded out when they got to sign things. It's a whole lot easier to lie to someone than it is to sign something where you lie to someone. Mentally, people get really weirded out about signing things. And so, I can assist you in drafting forms to that effect if you have concerns that it may be abused. Because, as I say, you think about your own personal income tax. When you used to have to sign it, and then it had that big bold, we'll put you in jail if you lie on here. That registers with people, and so we can put something on a form that says, if you lie about needing this, well, be subject to discipline up to and including termination for cause. So that may assist and alleviate some employers' fears that these forms of leave will be abused. But beyond that, I joked online about, because this is the kind of guy I am. I joked online about bereavement leave, and the Seinfeld episode, if you recall it, where George Costanza had to go to a funeral. There was this perception that if you're going to a funeral, the airline would give you 50% off, but they needed proof that you were there. They needed evidence of reasonable circumstances. So George takes pain through the episode to get a copy of the death certificate. He can't get it. And so he essentially takes a selfie with the casket to prove that he was at a funeral. He tries to tender that, and the airline says, no, that's not going to work. I've put this up on Twitter and said, what's going to count. People have suggested employees should bring in a box of used tissues to demonstrate that they were sick. They should take horrible, awful selfies of themselves looking miserable on the couch, et cetera, which they can send in. Look, I don't know what's going to cut it and what's not. I know a lot of my employer clients probably don't want a Ziploc bag full of used Kleenex. But hey, it's something to think about. And certainly selfies of sick people will be hilarious to look at. So, that's not an awful idea. Scheduling changes, and I'm probably going to go out on this, I think. Bear in mind, scheduling changes do not come into effect until next year. And so these are already being impacted by regulation. We're already seeing municipalities and firefighters and volunteer firefighters slowly being exempted from this. I think we're going to see a lot more exemptions to this. And certainly bear in mind, there's a provincial election coming. And if the election change the government, who knows what's going to happen before January 1, 2019 comes into effect. So scheduling changes. First and foremost, employees will now be eligible to ask for changes to their work location or their work schedule. And so employers are going to have to record these requests. They're actually going to have to keep track of these requests and keep track of the requests as they come in. This probably isn't the biggest change that people are concerned about. New changes with respect to minimum wage. And so essentially, you got to pay employees for being on call. And for what it's worth, that's going to be even if you make changes 48 hours before their shift was supposed to start. And so if an employee is scheduled to work and you cancel their shift less than 2 days before it's supposed to start to work, you're going to have to pay them at least 3 hours of wages for that shift. For what it's worth, employees can now refuse to work unless you give them 4 days advance notice of what their shift is going to be. So those of you doing scheduling are going to have to turn your mind to scheduling much further out. And so you may want to look at your vacation policies and how long people have to request vacation in advance. If they don't have to request vacation in writing, you might want to start thinking about doing that. Because it's going to get a lot harder to schedule people because they have the right to refuse, and you can't penalize them for refusing. That's an act of reprisal. So it's now going to be at least a week out. Any changes or cancellations made on short notice, you're going to have to pay them as if they worked anyways, and you're also going to have extensive record keeping as to all these changes. And so the Ministry of Labor has said once a schedule is set, you're going to have to keep records of what that schedule was. And if there's any changes, you got to keep records about those changes as well. In addition to any changes your employee requests, you're going to have to keep all of that paperwork You're gonna have to keep it for years in case the ministry ever comes and audits to see what's going on and make sure that you're properly paying employees. So just bear in mind, come January 1, 2019, you know, the scheduling is going to get a lot harder. Exemptions to this rule: weather, essentially right now. So fire, flood, snow, freezing rain. Coincidentally enough, for those of you in Ottawa, those are going to be allowable. So if the power goes out, or if for some other reason unforeseen by you can't that day, you're not going to have to pay them the 3 hours. There's going to be a mercy rule, so to speak, in that respect. But otherwise, yeah, just be mindful of your scheduling. Other exemption, because I know I have some municipality clients watching. If the worker is providing an essential public service, they're on call, but they're not actually required to work. So essentially, you know, I think snowplow operators are going to be covered by this. So looks like it's going to snow, stand by, and lo and behold, it doesn't. You know, the meteorologist gets it wrong, shockingly. Then you don't have to pay them if they don't actually work, if they're supposed to do an essential public service and they don't actually work. Enforcement, so new changes. Employees are no longer required to tell you that they're going to complain to the ESA before they do so. So it's a silly rule, not really widely regarded in any event. But in short, employees can now just go off and run off to the Ministry of Labor without telling you that they're going to do so. Employment standards officers, so the Ministry Police can now order employers to pay wages directly to employees. Fines are going up for what it's worth. Fines are going up all over the board. Just be mindful of that. There's some other sort of technical things going in there that I'm not going to go too far into. It's on the slides, as you can see. But in short, ESA officers, so employment standards officers, are getting more power. They're getting the ability to do more things, and the cost of doing business is going up. So just FYI on that. That's me. My contact information, you can find me on my blog, on LinkedIn. I do not have an Instagram account because I have a face for print. That's why I blog. I don't do a lot of these webcasts.
You have a voice for radio, Sean.
Well, as long as I don't have to listen to it. So I think Keith has some questions that have come in. There may have been some other questions that come in. I see my Twitter was lit up, but I haven't, Keith, I haven't had a chance to look at that. So.
All right, let me just open up these questions. Oh, we got a lot of questions coming in.
So apparently the audio was bad.
No, that was just at the beginning. We're all good now.
Okay.
That's once we got going, it sounds like the sound was good. Sean, I know we did have a couple of questions that you addressed. One on the size of the employees. There was one on not-for-profits as well, and if it was applicable to not-for-profits.
Which
all these changes?
Yeah.
That are employing. It was a question about not-for-profits and part-time employees.
Yeah, and so Georgia, the answer is yeah. The government doesn't seem to be too interested in the size of your operation or what you do. I think the minister's been quite clear on that. So sorry. See a question of, do the 3 weeks of paid vacation apply to professions exempted from minimum wage? Can you throw me that there? So if you look at, and I appreciate this is more my job than yours, but there is a regulation made under the ESA, and that if you look for it, the magic number is Ontario Regulation 285/01. So 285/01 is the exemptions, special rules, and establishment of minimum wage regulation. And so this is all the carve-outs, or a lot of the carve-outs to what we're talking about. And so there is what I call these 711 exemptions. And the reason that they're called these 711 exemptions is because in this regulation, Part 2 or Section 2 says Parts 7 to 11 of the ESA do not apply to various professional people. And so, what are sections 7 to 11? So 7 to 11 are hours of work, overtime, minimum wage, public holidays, and vacation. And so to the direct question, do the 3 weeks of paid vacation apply to professionals and other exemptions? Sorry, if you are a newly qualified practitioner of architecture, law, professional engineering, public accounting, surveying, or veterinary science, you are exempted. Your employer does not have to provide you that leave. There are others, mainly a lot of medical professionals, but yeah, look at 285/01. Next question. For a medical leave, does the employer have to accrue vacation time while they are away from work? Yes. So if they are on a protected form of leave, so any of the ones in part, I think it's part 14 of the Act, including personal emergency leave, reservist leave, child disappearance, child murder leave, the employee continues to accrue vacation time. What they don't continue to accrue is vacation pay. So there's a difference between vacation time and vacation pay. In the Act, it's not in a lot of contracts of employment, and gets conflated inappropriately. So you're going to want to look at what your contract says and maybe get it reviewed, because a lot of contracts of employment are not actually consistent with the wording of the ESA. So yeah, Keith's driving the bus here. How is child defined? I don't know. I believe it's 18. Around that, but I believe it is 18 as to what a child is defined with respect to child death, child disappearance, and child for I don't know with respect to domestic and sexual violence. I have to imagine it's higher. I don't have the specifics on that. I'm sorry. So next one. For personal emergency leave, if you have someone working on a 6-month contract, for example, can you prorate the 10 days, or do you have to provide them the full amount? Full amount. Period. Sorry. If they've been employed for a week, the government or the law does not care how long you envision them working. So that's the answer to that. Conceivably, personal emergency leave can substitute any allowed paid sick leave. You're going to want to look at what you're doing. I think the answer is yes, but the terms of your contract, so long as they provide a better benefit than what the ESA allows, are permissible. But you're going to want to define in your contract what you're actually doing with paid leave and personal emergency leave. You're going to make sure that that the two work together, and you're not going to be required to do both. Yeah. Personal emergency leave laws, is that for the year? Yeah, it is. And so, vacation talks to a vacation entitlement year. It is for, I guess your question is that per calendar year or per employee tenure year? I don't know. The law has not, I think the law has actually said that. So I don't know for sure. I'm going to guess, based on the way that vacation works and its establishment of a vacation entitlement year, that it's calendar. But I don't know for certain. I can look into that if that's something you actually need to know. But in short, it says per year, and I believe it's per calendar year. Yeah, that's my answer to that. Can we change our sick leave policy to personal emergency leave and references to cover off this requirement? For example, if we provide 5 days sick leave, can that cover off personal emergency leave? Yeah, in short, you're going to want to confirm that in writing to employees that essentially, if you currently provide 5 days of paid sick leave, that the first 2 will count as personal emergency leave if the employee hasn't taken personal emergency leave for other reasons. So bear in mind that personal emergency leave doesn't just apply to sick leave. As I said, it applies for bereavement and any other urgent situation to which the employee has to attend. So you're going to want to make sure in your employment policies and personnel policies that you are clear how it's going to apply, and you're not going to take away any sort of benefit. But in short, yeah, with some good drafting, yes. Is general annual medical checkup eligible for personal emergency leave? I don't believe so. It is not. It's not an urgent situation to which someone has to attend, and so no, I would say that that is not a personal emergency if it's a regular checkup. No. Okay. If we provide 10 personal leave sick days paid, could we act for a doctor's note? Yes and no is my answer to that. And so I looked at this yesterday for an employer. Not surprisingly, since about November, Bill 148 is all they're going to be done. So can you ask for a doctor's note to justify paid sick leave if that paid sick leave is in addition to the 2 days of personal emergency leave? My answer is yes. So if you're providing a contractual benefit, i.e. days in addition to those 2 days of statutory personal emergency leave, and you're going to pay them for them, then yeah, you can say that the consideration for those contractual days is a doctor's note. I don't see any reason why you can't ask for a doctor's note to justify a request for a contractual benefit. The ESA only says that you can't ask for a doctor's note to justify the statutory leave. But if you're going to provide a better benefit, then to my mind, yes, you can continue to ask for a doctor's note. This is going to get challenging because doctors are going to think they don't have to do it. The request to remove the doctor's note was pushed pretty heavily, for what it's worth, by family doctors who don't like this sort of thing. So, if that's the route you want to go, you may want to offer paying for the doctor's note. People are responsive to that. Doctors are going to be responsive to that. How much should you offer? Realistically, $100 to $150 to the physician for preparing the note. I mean that sincerely. So yes, you can ask for it, but bear in mind, doctors are now going to believe that they don't have to do this, and so you may actually encounter more resistance than you think from the family physician who says, "I don't want to do this." Excuse me. If an employee is scheduled for 6, but we need that to be need them to work 10, is that considered a change? Yep. They can refuse to work those additional hours, and so I have employers say, "Well, I might need them for 10. Do I just schedule it from 10 and then change it the other way?" Well, bear in mind there's going to be minimum payment obligations, so that's going to tick in. For what it's worth, the person asking this question comments that they work with truck logistics. Bear in mind that I'm talking about the Employment Standards Act of Ontario. Certain industries are not covered by Ontario law. This is way more complex than I want to get into right now, but thanks to those in 19th century England who drafted the British North America Act, some employers are governed by Ontario law, some employers are governed by federal law. Interprovincial trucking is or can be one of those industries that's actually federally regulated, which means that everything I just talked about doesn't really apply because the ESA doesn't apply at all. So if you're concerned your industry doesn't apply, drop me a note and we can have a conversation about which laws actually apply. So I put that out there.
All right, and here we are with our last question of the morning. Afternoon.
Yeah, so same question. Leave of absence. Yep. Didn't say if it was yearly or just when they want it, i.e. can they and do they claim this monthly? So it's annual. So the amounts are annual. I hope that answers that question. Something that came in advance was whether or not employees have to give you advance notice that they're going to take personal emergency leave. No, and you cannot contract that they must. that's simply the answer to that. Any attempt to contract out of the ESA or reduce it is going to be void. So no, they can advise you after that they needed to take it. So subject to anything else coming in. Sorry, I didn't look at my Twitter screen, but probably wasn't about this. Those are the answers. That's the presentation. Anything else, hit me up on any number of my social media platforms, or drop me an email or give me a call, and I'll be happy to look at it. Otherwise, that's about it for today.
Yep. Thank you very much, everyone. Waiting 5 minutes to 1, so time to finish your sandwich before heading back to your desk. Thank you all for all the and updating everyone on the new laws. Webinar will be on YouTube for colleagues who couldn't make it today, and of course, everybody, and wishing you a very good day.